standard constitute the security. Okay? The elements of the security. Number 3, I will explain the difference between the equity instrument and the debt instruments. Number 4, I'll explain you the fundamental lessons behind security regulations and legal process that leads to issuance of original securities. Number 5, I will describe the law of security of exchange commissions. Number 6, I will list the major categories of securities and transactions that are exempt from registration requirements. Some category of securities cannot register to the Security and Exchange Commission. They are exempt from registrations. Number 7, I will explain the ethical duties and legal duties of corporate insiders. Number 8, we will discuss the legal standard. Legal standard that is necessary to bring a security fraud action against the directors and officers and management. Number 9, I will explain the law of state blue sky laws in security regulations. 10, I will explain you the very, very important Act, Sarbanes-Oxley Act. Sarbanes-Oxley Act of 2002 impact the corporate officers and directors and its corporate governances. Sarbanes is a former senator, congressman. Oxley is a Democratic congressman. Just overview. This chapter begins with the overview of the security market. Overview of legal definition of security. Overview of categories of securities. Overview of regulation of security issuance and security transactions. This chapter begins with the background and scope of primary and secondary security market and the role of regulatory agencies in enforcement. And lists the major classification of securities and the rules that regulate their issuance of security, sales of security, trading of security, and Security Act provide the exemptions from certain securities. Finally, this chapter covers the corporate governance and regulations of a broad financial market. Historical overview. The laws regarding the securities began at the turn of the 20th century, and security laws had been developed very quickly after the 1925 stock market crash. Federal securities regulations. Two types of federal security regulations. 1933, 1934 was the response to the stock market crash of 1929. Following picture illustrated that in response to the crash, the Congress enacted the disclosure scheme to the public. Overview of the security market. Securities transactions occur in two types, two settings. First type of security transaction are the original issuance of security by a business in order to borrowing the money, in order to raise the capital. That is known as the primary market. Primary market regulate the original, include the original issues of security. Second type, purchase and sale of issued securities between the individual investors. That is known as a security market. 1934 Security Act regulated the secondary market. 1933 Act regulated the primary market. Both of these two types of market are governed by the federal security laws and state security laws. Definition of security. Federal security statute defines the security in two types, two ways. First type of definition is that recognize specific form of security such as the note, common stocks, treasury stock, preferred stock, transferable shares, bonds, debentures are defined as securities. Second type of security include that second way provide a catch-all definition of other investment transactions in a more general sense. Second type of definition is a broad concept. Profit sharing agreement is a security. Collateral, trust, certificate is a security, is treated as security. Free organization, certificate, or subscriptions is a security. Investment contract is a security. Fractional, undivided interest in gas, oil, or minerals is a security. Okay? Therefore, security, definition of security is a broad concept. Narrow concept is only the bond, stock is a security. Okay? A security is any, under these definitions, a security is any investment where a person gives something, gives legal value with the expectation of profit, with the expectation of future profit through the efforts of the third party. Is defined as a security. Okay. Modern application of how we test. The federal court now apply a sweeping, broad standard for the security, definition of security. This how we test include the investment itself standard, commonality standard, profit expectation standard, and efforts of other standard. Okay? Under the investment standard, in the Howey cases, investment may be cash or non-cash, where the investor's primary motive is an expectation of profit that is treated as a security. Under the commonality standard, in the Howey cases, an investment scheme satisfies these requirements either through horizontal commonality or by a vertical commonality. That investment is treated, that investment scheme are treated as a security under the Howey test, Howey case test. Third standard is a profit expectation standard. Under the profit expectation standard in Howey cases, the expectation of return on investment must be the primary reason for investment. Therefore, the expectation of return on investments are treated as a security under the Howey test. Finally, under the effort of other standard, the efforts of promoters or the agent of the promoters must be the primary source of revenue that resulted in profit. Therefore, the efforts of the promoters or agent of promoters can be treated as a security under the Howey test. Okay, 1946, very, very famous cases for the definition of security is Security Exchange Commission versus Howey campaign. Okay, under these famous cases, the federal court held that, decided that sale of plots in an Orange Globe plus a management contract were the sale of securities. Sale of plot were the sale of security because the investment contract was an investment of money in the common enterprise with the future expectation of profits solely from the efforts of others. That is known as a Howey test. Very, very important cases for the definition of security. Categories of securities. The securities fall into one of two general categories: equity instrument and debt instrument. equity instrument represent the ownership, such as common stock, preferred stock. Common stock and preferred stock is the example of equity instruments. That instrument is a tool for raising a capital. The bonds and debentures are the example of that instrument. Common stock. Common stock holders, common share owners, share in profit through the payment of the dividends from the company. Common stockholders bear, however, common stock bear the greatest risk of losses because common stockholders are typically subordinated to all creditors and subordinated preferred stockholders. If corporation files for bankruptcy protections, what does it mean? If the company bankruptcies, the remaining asset must distribute it first to the creditors, such as bank, and second, distribute it to the preferred stockholders, and remaining asset is existed, then common stockholders can receive a remaining asset. Therefore, common stockholders must bear the greater risk of their investment. Preferred stock. An alternative form of equity that has less risk than the common stock. Preferred stock is an alternative form of equity. Common stock, preferred stock has a less risk than the common stock. Common stock is the highest risk. Preferred stock is less risk because it has certain quasi-debt feature. Preferred stock has certain quasi-debt characteristics. Perhaps the biggest advantage of a preferred stock is that preferred stockholders have preferences right over common stockholders in receiving the dividend from the corporation. The first, okay, bond and debentures. Bond and debentures represent the borrowing of money from investors in order to raise the capital. Larger corporations prefer bonds as a method of splitting off. It's a long-term debt and blend the use of debt bonds with the conventional Lordland loans for short-term debt. Okay, bond is a company's debt. Debenture is also the company's debt. However, a debenture guarantee the attachment to the provide security to the lenders and investors. Okay, the Federal Administrative Agents is a Security and Exchange Commission. Security and Exchange Commission is a federal administrative agency. This agency is charged with the rule making of securities and charged with the enforcement of security and the adjudication of federal security laws. Okay. Unlike many federal administrative agencies, the Securities and Exchange Commission is an independent agency. Independent agency does not have a seat in the cabinet, government administrative cabinet, and is not subject to direct control by the president. SEC is an independent agency because SEC is an independent agency. EDGAR. EDGAR stands for Electronic Data Gathering, Analysis, and Retrieval System of the Securities and Exchange Commission. EDGAR is a SEC's public computer databases that provide the access to the public corporations, to the public investors, and provide the filing required by federal security laws. In addition to the EDGAR system, EDGAR computer systems, the SEC's website also serves as a source of information to educate the public investors on risks and provide the SEC's procedures. Under the address of SEC's website is under the bottom of this slide, appear under the bottom of this slide. Okay, I told you there are only two types of Security Act. First type is a Security Act of 1933. Security Act of 1933 regulated the primary market. Security Act of 1934 regulated the secondary market. 1933 Security Act covers regulating the process of issuing the security and de-issuing the security to the public. This act requires registrations and certain disclosure and authorize the Security and Exchange Commissions to control, to oversee the transactions. 1933 Act regulated the process of security, sale of securities, while they passed from the hands, the security passed from the hands of original issuers into the hands of primary public investors. This act regulates the primary market for security. Two principal regulatory components of this 1933 Act includes registration provisions and liability provisions. Two big categories of this Act are registration provisions and the liability provisions. First, component is a registration of securities. Under the 1933 Act, an issuer may not offer to sell the securities unless securities are registered with the SEC or exempt from the registrations. What does it mean? If Securities and Exchange Commission agents does not approve and not registered with the SEC, the issuer cannot sell the securities to the primary market. This registration requires underwriting. Who is underwriting? The investors of the primary market is referred as underwriting. Underwriting company, only underwriting company can board the original issues of securities. Okay. There are three types of underwriting: standby underwriting, best effort underwriting, and firm commitment underwriting. Registration of security with the SEC. The first step, in order to issue the securities, the first job is to register the documents with the Security and Exchange Commission. Okay? Pre-registration documents includes the letter of intent, comfort letters, and underwriting agreements. These three documents must be registered with the federal SEC agencies. Registering the security is a very complex process. There are 4 steps. There are 4 phases in the process of registering. Okay, first phase is a prospectus phases. Second step is a supplemental information submitted phase. Third step is a SEC review step. Fourth step is the sale of security phase. Okay, this slide table 17.1 illustrate the 4 phases of security registrations. Under the first free registration phases, the proposed issuer assembles pre-registration documents such as letter of intents and underwriting agreements with the SEC is the first phase. Second phase is a registration statement. Under this phase, proposed issue draft the prospectus. Prospectus means the future business plan. Draft prospectus with disclosures and financial informations and submit the statements to the SEC. Third phase is a SEC review. Under this phase, the SEC review the registration statement over the period of 10 days. Final step is said may approve the issuance of stock or refuse the issuance of stock. Okay? Prospectus. If you finance, if you fund the capital, first job is to submit the prospectus with the SEC. Okay? The prospectus is the sales documents of offering. Registered under the 1933 Act. Most of the information in the registration statement must be included in the prospectus. A prospectus allows potential public investors to base the investment decision on all relevant data about the issuing company. Exemption from registrations. Some company can be exempt from registration with the SEC in order to assist the business ventures who is seeking the smaller amount of capital from public investment. Some company want to fund the only small amount of capital. In that cases, Security Law 1933 Act allow a number of exemptions from registrations for the small amount of issues. There are two types of exemptions from the registration requirements of 1933 Act. First type of exemption is a security exemption. Second type of exemption is a transaction exemptions. Exemption transaction exempt securities cannot be needed to be registered with the SEC. Okay. There are some type of securities that are exempt the registrations with the SEC. Okay. Exempt securities includes the following securities. The government issuance securities are exempt from the registrations with the SEC. What is the government issued securities? Example of a government issued security is a municipal bond. Municipal bond is a government issued securities. Another type of securities, exempt security, are security issued by bank, security issued by other institutions that is subject to government supervisions, government control. Third type of exempt security is a commercial paper, such as the promissory note, with a maturity date of less than 9 months. It means that within the 9 months, the principal amount must be paid. Okay? Fourth type of exempt security is a security of charitable organizations. The church, example, non-governmental organizations security and church securities, issued securities are exempt from the restorations. Another type of exempt security is the annual and other issuance of insurance company. Okay, second type of exemption is the transaction exemptions. These exemptions are only for the transaction in which security are sold. At the beginning of the class, I told you this chapter may be difficult for you because these topics are strange, unfamiliar with the original people, the ordinary people, or all these concepts and terminology are new for the students. Okay. But you have a lot of money, you must know this knowledge of securities. Okay. 1933 Act lists some type of exemptions. First, type of exemption is the Rule 147 of 1933 Act regulated the intrastate offering exemptions. Rule 506 of Regulation D regulated the private offerings. Private offering means the securities are not offered to the public but are instead sold to the individual private persons or sold to the accredited investors. Other sections regulate the exemption for the small offering transactions. Rule 504 or regulated the public under the rule 504, non-public issuer can sell maximum $1 million of security without the restorations. Under the rule 505 of 1933 Act, any issuers can sell maximum $5 million of security within 1 year. Under the Regulation A of 1933 Act, non-public issuer can sell maximum $5 million of security within 1 year. Those securities are exempt from restorations with the said Rule 147 intra-state offering exemptions. Under the Rule 147 of 1933 Act, offering securities sold to investors in one state by issuer residents and doing 80% of firms which in that state can issue the security without the restorations. Okay? However, state security law may require restorations for such federal exempt securities. Okay. Regulation D regulates private offering exemptions. Rule 506, Regulation D, exempt the private offering, maximum $5 million to less than 35 uncredited purchases from restoration requirements. Accredited investors include institutional investors such as the bank, mutual funds, various investors, and high-level insiders of issues such as executive officers, such as the president, vice president, CFO, COO, and directors, and partners. Okay. Small offering are exempt from the restorations. Rule 504 and 505 provide the exemptions for small security offering transactions. Rule 504, Regulation D. Under the Rule 504, non-public issuer can sell maximum $1 million of securities in a 12 months period to any purchasers. Under the Rule 505, any issuer can sell maximum $5 million of securities within a 1 year period to less than 35 uncredited investors. Okay, a second category of 1933 Act is liability provisions. First category is pre-registration provisions, and second category is liability provisions. The 1933 Act, Section 11, imposed the civil penalties and criminal penalties on those operators and sellers of securities who violate the 1933 Act provisions. Penalties includes 30 types of penalties: rejection of the investment, cancel, avoid of the investment. Second, civil penalties and fines. Third type of liability is criminal penalties. That is incarcerations for egregious cases. Incarceration means jail up to 5 years who violated the provisions. Section 11, defenses against the penalties. Section 11 of 1933 established civil liability for damages when a restoration statement misstate or omit the material fact. Omit the material fact means the omitted the very important data for the public investors. In that cases, Section 11 established the liability for the damages. Okay, I finished the Security Act of 1933. Security Act of 1933 regulated on the primary security market. Okay? This slide is a quick test. Your knowledge for 1933 Act. True or false questions. The SAC has on executive power to impose the congressional statute. True or false? False, because SAC has executive power, administrative power, and the judiciary power. Okay, therefore false. Most SAC actions are resolved through the consent orders rather than litigations, rather than the actions. True. The 1933 Act regulates the sale of securities while they passed from the hands of original issuer into the hands of public investors. True. Okay? That is the goal of 1933 Act. Restoration requires underwriting by corporate insiders and financial control. False. The Howey test is used to determine whether an investment contract is a security or not. True. The restoration statement is the sales documents of offering vested under the 1933 Act. False. Not a sales document. Restoration documents. Okay? All securities are exempt from restoration unless specifically required to restore by statute. False. Only several regulations, sections of 1933 regulated the exemption from restoration due to the SAC. Rule 506, Regulation B, exempt the private offering to less than 35 uncredited purchases from registration requirements. True. Rule 504 and Rule 505 provide exemption from restorations for offering security valued at less than $10 million. False. Less than $1 million. Section 4 with $5 million. Okay. Section 11 establishes civil liability or damages when restoration statement misstate the fact or omit the material fact. True. There are 5 penalties. Okay. There are 3 types of penalties who violated Section 11. Okay. Multiple choice. The important time period in the life of security offerings are A. Pre-filing period, B. Waiting period, C. Post-effective period, D. All of the above. Correct answer is D. These 3 periods is for the life of security offering. Okay. Second, B category of Security Act is a Security Exchange Act of 1934. This 1934 Act regulated secondary security market. Okay. 1934 Act requires periodic disclosures, normally the semi-annual or maximum the 1 year. Okay, requires periodic disclosures of material information by the issuer company with the public held security equity securities. Therefore, public company must disclose every material fact to the public investors under the 1934 Act. The purpose of 1934 Act is to protect the public investors after the issue, after the public company issuing public company become issuer become a public company. Okay? 1934 Act also regulated inside transactions in securities. Inside. Who is the insiders? Management is the insiders. Anybody who have more than some percentage of common stock is treated as insiders. 1934 Act also regulated inside transactions and proxy solicitations, regulated proxy solicitations and regulated tender offers, regulated broker and sellers, regulated security exchange in the secondary market. Okay, therefore, 1934 Act is broadly regulated the financial market. Okay? Section 10b and Rule 10b-5 of 1934 Act. Section 10b broadly prohibits use of any manipulative and deceptive device in contravention of any SAC rules that is prescribed as a necessary or appropriate in the public interest or for the protection of investors. Okay. Rule 10b-5 and Section 10b is a primary anti-fraud provisions, anti-regulated in the fraud. Also, it covers the trading of securities. Section 10b makes it a criminal offenses to engage in any fraud if anybody, such as the inside managers, engaged in any fraud. In that cases, that person who committed the fraud received a criminal penalty under the Section 10b of 1934 Act. Rule 10b-5 of 1934 Act specify the elements of prohibition and applies to all transactions in all securities, whether or not registered under 1933 or 1934 Act. Inside trading, Rule 10b-5 prohibited the person with prohibited inside trading. Who is the insiders? Insiders includes executives, managers, corporate counsels, partners, vendors, accountants, brokers, dealers, employees, major shareholders. Therefore, inside is a broad concept. Inside is anyone who confidential corporate informations for a corporate purpose. Inside is anybody who has confidential information for the corporate purpose. TP, receive inside. TP is the person who receives inside information from the tipper. Tipper and TP liability. Both tipper and TP are liable for violating Rule 25 if the information released by the tipper constitutes a breach of tipper's fiduciary duty, or the tipper obtained some personal benefit by giving the confidential information to the TP in the cases. The tipper violated Rule 25. The TP knew and should have known that that information was wrongfully disclosed. And the TP are benefited from that information. In that cases, TP is liable for violating the Rule 25. Section 16. Section 16 classify any person who is the executive office director or shareholders with 10% or more ownership of total stock as an insider. That person are treated as an insider. Therefore, the insider must have responsible for the Rule 25 provisions. Section 16 require these insiders to file the regular reports with the SEC. Okay, report include the my ownership percentage is some blah blah, and I trade the stock with any other person. Okay, the inside must define the regular reports with the SEC. Section 16B is a clawback provisions that allow a corporation recapture any profit, recapture any profit earned by the insider on the purchase or sale of a company stock that occur within a 6 months period. These earnings are called short swing profit. Okay, I finished the second type of Security Act, and currently a new Security Act is amended. Okay? Private Security Litigation Reform Act of 1995. The Private Security Litigation Reform Act made it more difficult to pursue the litigations, file a suit, file an action. It's difficult under this act based on the commentary by companies' executives. This act provides safe harbor rules, safe harbor provisions from lawsuit that shield the company, that protect the company, and protect its officers, and protect the company director, so long as the principals act in good faith and disclose all relevant facts to the public. In that cases, the officers, the directors are protected from this Reform Act. Security Litigation Uniform Standard Act of 1998 is an amendment to the 1994 Act. This act is intended to prevent the private power from instituting the certain lawsuit in a federal court or state court based on the statutory or common law of any state. That common law or a state law punish the misrepresentation or omission of a material fact concerning the purchase of security and sale of covered security. Okay? Therefore, it's very difficult to file action against the management under this act. Okay, security regulation by statute. State Security Act is referred as a blue sky law. Blue sky law. A majority of states have adopted all of the Uniform Security Act. However, some state security laws intended to cover public intrastate securities offerings and serve as additional safeguard. State security law provide additional safeguard for investors when federal government deny to exercise their jurisdictions of a particular security offers. In that cases, state security law will be applied. Typical provisions of blue sky laws, typical provisions of state security law include the prohibition against fraud in the sale of security, restoration requirements for the brokers and dealers, exemptions, civil liability for issuers who is failing to comply the law, and remedies, compensation for defrauding investors. Okay, therefore, a blue sky law, state the security law has a lot of additional provisions. Sarbanes-Oxley Act of 2002, SAX. Sarbanes-Oxley Act was passed in response to the regulation corporate fraud and more many big companies issued the fraud financial statement. Therefore, Sarbanes-Oxley Act was established in 2002. This Sarbanes-Oxley law aims to solve specific mechanism failures in accounting method and requires higher level of fiduciary duties for the management. Okay, I'll write 5 minutes more. Reform on accounting industry. Sarbanes-Oxley Act seeks to increase auditor independence Under the Sarbanes-Oxley Act, the management must set the mandatory rotation of auditing partners. The public company must ban accounting firms from providing the non-auditing consulting services for public companies. Okay. If the accounting company provided the non-auditing consulting services, in that cases, that accounting company cannot audit that company's financial statements. Financial reporting. Sarbanes-Oxley Act make key corporate officers more accountable, more responsible for financial reporting by requiring that chief executive officers and chief financial officers must sign his or her personal, individually the financial statement, and the management personally certify the accuracy of all required SEC filings. If fraudulently sign, in the cases, then management are personally liable for the loss of public investors. Personally liable for the damages of public investors. Corporate governance. Public company must maintain audit committee in addition to the board of directors. Audit committee is independent committees. The audit committee must contain at least one director with sufficient financial acumen to prove audit indexes. Enforcement under the Sarbanes-Oxley law. Emergency escrow. Penalties. Officers who certify the required financial reports filing, knowing that the report is an inaccurate, false, that officers, that management are subject to criminal penalties. Criminal penalties includes the maximum $1 million in fines and 10 years in jail. And for cases in which certification was used as a part of larger fraudulent scheme, the penalties, civil penalties, increase in fines, and criminal penalty is 20 years in jail. Therefore, Sarbanes-Oxley Act is very strict. Whistleblower, the parties who communicate the inside information relating to any illegal conduct in financial reporting or corporate governance are protected against any retaliations. Okay? Whistleblowers are protected under the Sarbanes-Oxley Act. Document destruction rules. Anybody who destroys the documents, who alters the document, who conceals the documents is subject to maximum 20 years of jail, criminal penalty. Who destroyed the financial document, then management must go to the jail up to 10 years. Management must live in the jail up to 10 years. Conspiracy to commit fraud. The creation of a new federal criminal law outlawing the conspiracy to commit the fraud has made foreseeing the criminal fraud charges against the management, against officers, substantially easier for government prosecutors. Therefore, the government prosecutors easily prosecuted than management. Financial market regulations. Financial markets are regulated through a variety of administrative agencies and regulatory bodies. Okay. First, important regulation is the Wall Street Reform and Consumer Protection Act. The Federal Congress passed the Wall Street Reform and Consumer Protection Act in 2010 to fix the regulation of U.S. financial services and to fix the regulation of U.S. financial market. This Wall Street Reform Act consists of three big categories: Financial Stability Oversight Council, Bureau of Consumer Financial Protection, and our provision consists of big three components. The three components are as follows. Okay? State security laws. Okay, final slide. State security law. The state, every state has its own individual state security laws. State security laws, often called the blue sky laws. What does it mean, blue sky? Because only state security law work to protect investors from promoters and security salesmen. That security salesman can and would sell building lot in the blue sky. Therefore, state security law is referred as a blue sky laws. Most state security statutes have a restoration scheme, much like the 1933 Act. All state statutes have a limited number of exemptions, restoration exemptions and transaction exemptions. Okay. Okay, shortcuts. True or false? 1934 Act requires periodic disclosure of material information by issuers if the public have accurate security. True. Periodic reports include the Form 10K, Form 10Q, Form 8K. True. If corporation management select the proxy of a particular board, it must issue the information statement first, because corporate management must issue the proxy statement, not information statement. Okay? Only shareholders with at least 10% of equity in corporation may request the shareholder proposal to include in practice statement. Practice. Rule 25 define inside as anyone. Inside is any person with confidential corporate information for a corporate purpose. True. That is the definition of insiders. Multiple choice. Which of the following is false regarding regulation FDA? The company should establish clear rule for content of information that may be disclosed to the public. True. If an issue may disclose material non-public information to the stockbroker, it should immediately publicize the denial of that information. True. FD stands for fair disclosure process. Okay. A lawyer knows that client corporation is about to file a bankruptcy. Among the following, to whom the lawyer can relay this information? The lawyer